Hello, everyone. It's Attorney AMD here. In this video, we're going to talk about a lawsuit update, and this lawsuit update pertains to fast deportations or expedited removal. Okay, guys. A federal judge earlier this month issued a stay order basically pausing or halting the administration from being able to use or implement fast deportation against the CHNV parolees. Now, before we dive into what the stay order does and the scope of it, let me remind you how we even got here with this lawsuit and the stay order that was issued by the court. You'll recall we talked about on our channel several of different policies and different directives and moves that the Trump administration was implementing to be able to place as many individuals into fast deportation. One of the first memos that talked about this was the January Huffman memo. You'll recall that memo where we talked about this memo gave the immigration or ICE officers, it gave them guidance on how to exercise discretion to terminate paroles of many individuals, particularly if they had not applied for asylum, in order to be able to effectuate fast deportation. And then there was a directive in February issued to ICE officers to exercise again and consider expedited removal for certain individuals, particularly if those individuals in that instance were detained but then released from detention, to exercise where you could to re-detain individuals in order to be able to place them into fast deportation. And then the big one, guys, in March, where the administration announced the termination or the end of the CHNV parole program. Now, of course, as we talked about, the policy decision of the administration terminating CHNV definitely made it even more ripe for the administration to utilize fast deportation to be able to place individuals into fast deportation or expedited removal, especially for those who had not been continuously present in the United States for 2 years. Well, as I stated, this past week or earlier in this month, a federal judge has put a stay, and that just means the ability for the government to place individuals in fast deportation will not take place, certainly while the case is still being litigated and is pending. That's huge and is definitely going to be a game changer for many individuals. But there's more, guys, because the court's stay order doesn't just apply to those individuals who came in on CHNV parole, but it also applies to all non-citizens or immigrants who have been paroled into the United States at a port of entry at any time. That's huge because it opens up the scope of individuals who will not be subject to fast deportation. And so that is going to be huge. And so what does this really mean, having the stay in place? Well, as I said, having the stay in place is a pause on the administration being able to place individuals into fast deportation. But it also means, guys, that for many individuals who no longer have parole under CHNV, or maybe if you receive parole through the Southern Border or CBP-1 or anything like that, it allows you to be able to be in front of a immigration judge in a full immigration removal proceeding. And that is huge. Why? Because there's more protections, believe it or not, more protections in being able to have your particular immigration case in court before an immigration judge, because you can hire an attorney. You will have the ability to present and put on evidence. You will have the ability to be able to take the witness stand and tell your story. And if your immigration case does not go in your favor, you also have the ability to file an appeal with a higher court. that being the Board of Immigration and Appeals. So you have more access to due process when you are before the immigration court and an immigration judge versus being in fast deportation where your relief is limited to asylum or withholding or CAT. That's a huge difference because many individuals do have other forms of relief other than applying for asylum. But because if they're not in front of an immigration judge, access to being able to apply for additional relief that you may be eligible for is doesn't exist when you're in fast deportation or expedited removal. So for now, there is a stay and a pause with regards to fast deportation for individuals who have been paroled, and that applies not just to the CHNV parolees, but anyone paroled at any time. So that, in terms of the scope of the stay, is huge. And likewise, guys, as I always indicate to you, please be sure to work with a licensed immigration attorney regarding your immigration matter, because while this pause is in place, if you have other forms of relief, you definitely want to work with an attorney to explore all of your options. I do thank you kindly for watching the video. Please be sure to like, share, and subscribe, and I will definitely, guys, see you in the next one. Bye-bye.